Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing recent changes to the public charge rule and the K-3, CR-1, and IR-1 visas, specifically processing through the embassy here in Thailand. And I've had some questions from folks regarding whether or not the Trump administration's old public charge, which is now kind of the old public charge rule, which in essence was a new rule, which has now effectively been rescinded by the new administration. But there was a recent, well, I shouldn't say recent. I'm going to go ahead and read this from travel.state.gov. This is from the State Department. I'm going to go ahead and read this, then do the analysis so I can let people know where this all is. Quoting directly, update on public charge. This is August 7th, 2020. Again, this is from Department of State. Again, travel.state.gov. Quoting directly, on Wednesday, July 29th, the United States District Court for the Southern District of New York enjoined the Department of State from, quote, enforcing, applying, implementing, or treating as effective the Department's October 2019 interim final rule and accompanying Foreign Affairs Manual guidance related to the public charge ground of visa ineligibility. The Department is complying with the court's order and is in the process of updating its guidance to consular officers on how to proceed under the preliminary injunction. In the interim, visa applications that appear to be ineligible under INA 212A4 will be refused for administrative processing to allow for consultation with the Department, including legal review to ensure compliance with applicable court orders. Visa applicants are not requested to take any additional steps at this time and should attend their visa interviews as scheduled. Applicants are not required to complete, nor should they present, the DS-5540 public charge questionnaire. So, Department of State, acting on the injunction of the federal court, was ignoring Trump's rule back in August. Okay? Recently, the Biden administration, specifically Department of Homeland Security, has come out and said that they will not pursue defending that rule that was made. And so essentially, where does this leave us? Well, as a practical matter, the rule is dead on the vine. Now, could there be ongoing ramifications as there was a rule change? And there's always sort of this kind of detritus, if you will, sort of left when you have these circumstances in the bureaucracy where they've created forms and some people have started doing things under new rules and only to be rescinded. So yeah, there could be ongoing ramifications. But long story short, at least for the immediately foreseeable future, I do not see these public charge issues being of major concern to those processing a K-3 marriage visa, a CR-1 marriage visa, or an IR-1 marriage visa for the spouse of a lawful permanent resident or American citizen processing their visa case through the U.S. Embassy here in Thailand in the relatively near-term foreseeable future, and maybe even out a couple of years.